Hello, Kira.
Hello, Stuart.
Good to be with you today. A lovely summer day here for us. They wouldn't know we've now moved. We have a bookcase behind us now because we're very intelligent and have read all these books behind us.
Very studious.
As opposed to the normal window look we have outside. But I assure you it is a nice day outside. So today we're discussing what I think is a relatively neat, novel case that has come out a couple weeks ago now, I think, called Nelson and Trottier. At least that's how I'm pronouncing it. And the basic kind of issue in the case is mutual wills. So, what's a mutual will? For those who don't know, a mutual will is most often comes up in second marriage scenarios. Usually, there's two people coming together, each with kids from a prior relationship, and basically you do the same. You do wills that are kind of mirrors of each other, and you enter into agreement that you won't change your will after the first one dies. And why do you do that? Well, the concern is if you leave everything in your will to your surviving spouse, as opposed to your kids from your biological kids from your first marriage, that when everything goes to the spouse, they're going to cut your kids out when they pass away, and your kids get nothing. So usually, most often, these scenarios you see is everything goes to surviving spouse, and then surviving spouse agrees to give everything to all kids from all marriages, biological or not, after they pass away. Normally, the kind of the estate law statutes in Ontario, at least, can't stop someone from doing a new will. If you have capacity, you can always do a new will, but a mutual will in effect is a contract not to do a new will. So you have by contract agreed not to change your will. Therefore, even if after the spouse passes away, if you change your will, you can change the will itself may be valid, but there's a constructive trust imposed over your estate because you've contracted out that ability. That's kind of on high level stuff here. What is a mutual will? That kind of leads us into this discussion of this case. That's interesting here because this case, Nelson and Trottier, and we'll have the citation hopefully up on the link that goes with this podcast, is a circumstance in which while one of the spouses has died, the second spouse, the wife in this instance, is still alive, and the kids from her dead husband's estate, or first marriage rather, are coming after saying, you owe us certain obligations even while you're alive because you had this mutual will.
Yeah, so what's different about this case is typically we see arguments relating to whether or not a mutual wills agreement exists at all, whereas in this case, everyone agrees that there is a mutual wills agreement. On October 13th, 2010, it looks like the parties executed wills, an agreement, and acknowledgement and direction to their lawyers, specifically speaking to the fact that these are mutual wills. But the question in this case is, what are the legal obligations of the survivor in the circumstances where there is a mutual wills agreement present? So this application was commenced by the deceased's children from his first marriage, Stephen, Deborah, and David, the applicants, and the respondent is his second wife. He died on November 3rd, 2016, and essentially, in broad strokes, what happened was she made a donation to a charity that the deceased had a significant connection with of $200,000, and the applicants were seeking the imposition of a constructive trust over that amount, over the estate, and amongst other things also orders that she repay the amount from her personal funds, essentially saying that she breached the mutual wills agreement. And importantly, one of the things that the mutual wills agreement said is that it actually talked about making such donations that may be, not contemplated. And so the issue here is not whether or not the mutual wills agreement existed, but rather was the respondent in breach of it.
Yeah, no, exactly. So it's an interesting case. So I said, wife and husband, no dispute, mutual will agreement. They contracted out the ability to change the wills after the first one died. After the, so husband's estate goes entirely to spouse, and in theory to wife, and then wife and her will is to send it over to all the kids eventually, but she's still alive. In here, so in this instance, there's no dispute. The wife has not changed her will, but the kids of husband have come forward and say, look, we don't like the fact that you just donated $200,000 to this charity, which was a school, college that the deceased husband had an association with. She was setting up a bursary or a scholarship there in his name. Said, hey, we don't like that $200,000 donation. Pay that back. And by the way, we want an accounting of your life, basically. We say that there's a constructive trust imposed over your world because of the fact that you can't change your your will, and you've entered this mutual will agreement, and we want an accounting of everything that you have done in your life. We want the $200,000 back, and you have to tell us everything about what's going on. These things are pretty restrictive things, right? I mean, this surviving spouse, husband's just passed away, and suddenly the kids from the first marriage are saying, you basically can't do anything. If you go to the grocery store, we're going to say, hey, you spent too much on groceries. If you went on a trip, we're going to say, hey, was that trip really necessary?
Yeah.
If you're going to donate money to a charity, we're going to say you shouldn't have done that. We want that money back. And these are big impositions on you. So the question here is, well, do you have that right while the second spouse is still alive? In this case, went to Justice Patillo here in Toronto. The basic issue here is what did the parties agree to? And he kind of goes through all the machinations of what was agreed to, the case law on point, and he comes to the conclusion basically that all that was agreed to here was that she wouldn't change her will. And she hasn't changed her will. And from his review of the case law, a constructive trust can be a remedy. So hypothetically speaking, if this wife had changed her will, now gave everything to her own kids or something like that, you can impose a constructive trust in those circumstances as a remedy. If she hasn't breached her agreement, which she hasn't here, the constructive trust doesn't yet exist.
Yeah.
And in the absence of that constructive trust existing because you haven't changed your will, you children have no right to an accounting. You aren't a beneficiary of your dad's estate. The dad's estate said that when everything went to the wife.
Absolutely.
So as a state trustee, which she was of husband's estate, she has no obligation to you to account. And we're not willing to create this hypothetical constructive trust if she hasn't violated her contract, which was, I won't change my will. So kids, so sad, bad luck, you don't have a right to control your stepmom while she's still alive. She doesn't have to tell you what she's spending her money on. That's her own right to do so, because she never contracted out of that ability.
And I think it's important to note too, if the court were to impose such an obligation on the respondent, that would be a very significant curtailing of her rights for the rest of her life. She's basically acting in trustee capacity and reporting on everything to these beneficiaries of an estate that technically does not yet exist.
Mm-hmm.
They don't become beneficiaries until she dies.
No, it's true.
So I think that was probably an important consideration for Justice Patillo, even though it wasn't really directly addressed here. And also the fact that this gift was $200,000 and the overall assets were like $4 million. So Justice Patillo really talked about how that doesn't really mean, it's not a substantive amount in comparison. And
so to jump to that gift then,
Yeah.
So Justice Patillo also eventually concluded that no, kids, you can't stop your stepmom from donating $200,000 to this charity. You don't have a right to have those funds paid back. And the rationale there, as Kira kind of mentioned there, look, this is a $4 million hypothetical, world here, estate eventually when it's getting passed on to you kids. $200,000 in the grand scheme of things, is not that much relative to this estate.
Yeah.
It's not, the purpose of the donation was not to defeat, in air quotes here, the agreement, the mutual will contract not to change your will, because she's giving it to a charity. I mean, here, heck, she's setting up a scholarship or a bursary in the deceased name, so it's not like she's giving the money away to someone random. So Justice Bill said, you know what, I'm not willing to step in here and stop that payment. She has every right to do so.
Yeah.
Now, interestingly, he left the door a little bit open here because he kind of says, look, the purpose of that payment was not to defeat the agreement. So we've kind of talked about this before coming on, on podcast today about, okay, fine, so you gave $200,000 to a charity, we're okay with that. But what if you gave that same $200,000 to one of your biological kids? Or what if you gave $2 million right before you pass away to one of your biological kids? You're still alive. The constructive trust hasn't yet been imposed because you haven't changed your will. But the effect of you donating all this money out of your world right before you die is in effect almost to defeat the mutual will because there's be no money left to go out in your estate. And the court doesn't say for sure here, but my gut is there's a little wiggle room there. Whereas if you did that, the court could say, you know what? No, I'm stepping in here. The purpose of that, gift or transfer was in effect to defeat the intentions of the mutual will, the contract you reached with your late husband, to have all the money go out to all the kids equally, and I'm not going to let that happen. Whether or not they do that, who knows? But that's my gut here, at least.
Yeah, Justice Patillo really seemed to go into the connection between this particular donation and the deceased. The deceased was involved in this college. There was a significant connection there, aside from the fact that it wasn't a large enough amount. So I think that there's more clarity on amount versus whether or not this particular donation is okay or not. Like, I think that if it was $1 million, the judge would probably say that's a lot in the grand scheme of things. But it's not clear whether or not he really placed importance on the type of donation. Like, as Stuart here mentioned, if it was $200,000 that she gave to one of her kids, would that allow the applicant's application to move forward? Who knows? But it sounds like there's some room there for argument that could potentially.
Yeah. It's important to note here, I mean, while in this instance Justice Patilla concluded that the kids from the first marriage had no ability to have an accounting of of stepmom's world or to stop that payment to the charity, that he's clear that what's most important here is that this is contract law, right? So it's what the parties agreed to when they entered into mutual agreements. So in this instance, Justice Patilla found that the two spouses had only agreed not to change their wills. But if, in theory, you could put on a whole bunch of more terms in that agreement. So if the mutual will agreement said, we can't change our wills. Oh, and by the way, once the first one of us passes away, the kids can ask for a yearly update on your finances or something like that. Well, then you probably would have to account. It's all dependent upon what you agreed to, right? This is contract law. So here, while the kids can't peek in, if you have an estate where maybe the parties agreed to more as part of their mutual will case, there could be some wiggle room here for asking for more.
Although one interesting point is, Justice Patilla found the applicants had no financial interest in the estate because they're not beneficiaries of the estate. It'd be interesting to consider what would happen if, say, the second wife did grant a gift to one of her children or did something that would otherwise amount to breach of this mutual wills agreement, but they have no way of knowing it. And so maybe years down the road that they find out about it, and who knows if there's any funds to go around at that point. So that's more
interesting hypotheticals.
Yeah.
Yeah, no, but it's an interesting case. It's a good kind of refresher on the concept of mutual wills, which we see, come up fairly frequently in the estates law world, but most frequently we see it after both spouses have passed away and the kids are fighting because inevitably one of the spouses changed their will and you're saying, hey, you couldn't do that. Right. This is kind of an interesting, scenario because stepmom/mom is still alive. She's still very much, then saying, hey, wait a second, you can't control my life while I'm still here. And at least in this instance, the court said, yeah, you're right, you can't. So interesting case. Maybe that kind of concludes our podcast for today. So until next time, I want to thank you for listening, and thank you, Kira, for being with me today.
Thank you, Stuart.
And if you have any questions, please feel free to email us at webmaster@hollandhall.com or leave a comment on our blog. Thank you very much.
Thank you.